Well, howdy, free people of the Rocky Mountain region. This is Brandon from freestatecolorado.com with your weekly news roundup for July 1st, 2023. Every week, I take a look at some headlines, articles, and news stories from across our great state to provide you some valuable information that you can use as either an activist, maybe somebody running for office, or just to be better informed about what's happening in Colorado. So, lots to talk about this week, of course, with the recent Supreme Court rulings that directly tie into a lot of Colorado issues, as well as some unfortunate news out of Denver with the rising crime rate, and of course, a new gas tax that Colorado lawmakers have burdened Colorado drivers with. Well, let's dive in and take a look. First article I want to talk about is from the great page2.completecolorado.com. Original reporting and commentary almost always makes the case for good liberty messages and really provides some valuable information that you won't find anywhere else. In this case, Complete Colorado is actually suing the state government for its failure to comply with Colorado Open Records Act request. Complete Colorado takes state health agency to court over withheld public records from June 26, 2023, by the great Sherry Pipe. After being unable to come to a satisfactory resolution with the Colorado Department of Healthcare Policy and Financing, the HCPF, the online news organization Complete Colorado has filed a petition in Denver District Court to compel the agency to show cause for holding back numerous documents as part of a Colorado Open Record Act CORA request. Of course, CORA is a huge tool for the liberty community in Colorado to gain access and transparency to communications that the government's involved in or other data or documents that they don't always make public. The request, originally filed in May, initially was purported to include almost 2,000 records. However, HCPF ultimately released just 318 documents, claiming the rest to be exempted by either attorney-client privilege or deliberative process privilege. So you can read what they did get out of the files, out of this CORA request. They go into detail on what the complaint is actually about, which is pretty interesting. So the bigger background, the bigger idea behind this is that among the records HCPF did release were emails that showed coordination between the department and progressive activists, who in turn had connections to the legislators carrying the bills this session that is set to change the way healthcare works in Colorado. So that's right, there's a coordinated effort by progressive, quote unquote, really authoritarian democratic activists who are working with state legislatures, both on the inside and out, to really try and reshape how Colorado's healthcare system works. I think this information should be public. I mean, it's in the public's interest to know how legislators are leveraging their activist networks to get bills passed and how they're working within state government agencies to push an agenda that maybe not all Coloradans are aware of or even agree with. The records request is part of an ongoing Complete Colorado investigation concerning 3 legislative bills that appeared to flow out of previous claims by Polis and HCPF that hospitals are making record profits, retaining record reserves, and spending less money to benefit the communities in which they operate. In the petition, attorneys argue that on March 10th, 2023, Snow, who is referenced earlier in this article, sent Complete Colorado an email stating that there were almost 2,000 records that fit within the search parameters of that email alone. So they only provided a small portion of those documents, and they're withholding them because they don't want that information to get out to the public. So pretty interesting that there's these hospital bills being pushed by progressive activists and their state legislative cronies, and they don't want the public to know about what's going on. So good on Complete Colorado, good for them, speaking out in defense of the people's right to know, fighting for transparency, and trying to push back against this hidden authoritarian class in Colorado politics that is working to strip away our freedom and liberty and push their own agenda on us without our consent. Let's move on and see what else is happening this week. Let's just check in Denver, see how things are going there. From the dailymail.com, British news magazine. I mean, what must they think of Colorado when they see articles like this, right? Colorado woman tells how she had a box of bees thrown at her from Nightmare Bus Stop outside her home, where homeless drug addicts sleep and urinate on her fence. Geez, is any wonder why people don't like taking RTD or like being in downtown Denver these days? I mean, absolutely crazy, right? Gwendolyn Castanoff said she is being terrorized by a group of drug addicts who are living in a bus stop adjacent to her home. Earlier this month, she said the group tossed a shoe-sized box filled with bees at her. She has since complained to the city of Denver to have the bus stop closed down. Wow. So can you imagine? Here's people living outside of this bus stop. This poor lady who lives there has bees thrown at her. There's just crime, open drug use, and public urination. So very unfortunate to see what's happening in Denver. Thought this article was interesting because it's kind of symbolic of some of the bigger issues that are happening. Let's take a look and see what else. CBSnews.com. Homelessness pushes out to the Colorado foothills and Denver suburbs. So, of course, very unfortunate what's happening in Denver, as we saw with the previous story. And, RTD's key in all of this, of course. I think it's not shocking that this article really took place at a bus stop. Of course, that's a key part of understanding the situation that's going on. And unfortunately, here in Colorado, we're seeing a use of the homelessness of the homeless community or criminal community more so. Not to really say that all homeless people are involved in crime, but unfortunately some of them are. Some of the reasons why they are homeless, of course. But it's pushing out to the Colorado foothills and Denver suburbs, right? So as we can see here, in an RTD lot next to an open power outlet, they made their home. Carrie Vernon and her boyfriend were living by a power box near a light pole in the green grass. There was a pile of things, including suitcase and clothes, covered by a loose tarp, but it hadn't been raining. Missed the bus that last 3 days because only 3 buses that leave here in the morning and 3 that come here in the afternoon. So if you miss them 3 buses, you're stuck here, she said. They had come to Evergreen to get away from the city. Denver, I will never stay down there, she said. It's like once the sun goes down, it's crazy. Crime and drugs and alcoholism among the homeless population are a worry. We've had a lot of stuff stolen. We've started over like 7 times because all our belongings are gone. So, a big concern, of course, is that this crime, this homelessness, this drug use issue is expanding past Denver city limits. And of course, they're using public transportation to move out into the communities. As we can see here, in Jefferson County, many of the homeless are originally from the area. There are no year-round overnight shelters in Jefferson County, so people either create their own shelter in places like parking lots or open space, or head into Denver, where there is overnight shelter. But during the day, many return. So very unfortunate to see this is happening. It's not something that's going to be solved easily, and there's many reasons to believe that this problem is going to get worse. So what is there to do about the homeless situation, about the crime situation that comes along with it? Well, here in Douglas County, we can see what they're doing about it. This is from KDVR.com, Fox 31. Douglas County, Colorado, from June 27th, 2023. Douglas County Commissioners on Tuesday unanimously passed a public camping ban. The ban will limit camping and ban temporary structures on public property in the area without written approval. Commissioners questioned how those words could affect enforcement. Would anything in this ordinance inherently prohibit that an organization like Boy Scouts, Girl Scouts, or some other youth camping organization from attempting to get and receive a camping permit? Commissioner George Teal asked before voting Tuesday. No written permission of any kind permits any organization or party to use public property. It's just the process of getting that approval, Douglas County Attorney Jeff Garcia said. Anyone who ignores the measure could face a fine of up to $1,000 if shelter space is available. Now, we've seen this happen in Denver, of course, with their camping ban, Aurora, other places doing similar types of policies. It's really a reaction to this growing homelessness and crime that we were seeing in our communities that is now spreading out across Colorado metro area outside of Denver. So not that I don't know that this is necessarily going to solve a problem. I don't think that this is necessarily going to make too much of a positive impact in the community, but it's interesting to see that solutions are being presented by local public officials, by elected politicians to try and do something about these issues. What is the solution? It's hard to say, but if you can come up with that solution, you can make a huge impact in turning Colorado around and making it a more positive community. That's for sure. Let's move on and see what else is going on. So, sticking with this issue for just a little bit longer here, from June 30th, 2023, Sean Boyd, formerly homeless man, says Denver will be next San Francisco if leaders don't change course. Denver's population has shrunk over the last 2 years, but one demographic continues to grow: the homeless. There were nearly 5,000 people unsheltered in Denver last year, the most ever, even as the city spent more money than ever to address homelessness, $250 million. Some of the state's top leaders are hoping to change the trajectory. They heard about a different kind of homeless strategy from an expert who lived with lived experience. While most major cities, including Denver, have addressed homelessness as a housing crisis, Wolf will tell you it's primarily a drug crisis. He ought to know. He lived on the streets of San Francisco for 6 months after becoming addicted to painkillers following surgery. It eventually spiraled into heroin, homelessness, fentanyl, and near death. I lost my wife, my kids, my job, my money. Everything that was of value to me, I had lost. He would be dead, he says, if he hadn't been arrested. I'm blessed. He says he was in jail long enough to get sober and get help from the Salvation Army, where he now works as a recovery advocate. I've tried to turn my negative experience into something positive, to give back to the community. It's part of my living amends to my family and my community in recovery, and it gives me great strength to be able to go out there and share my story. So, what should be done? I guess is the question, right? He says San Francisco's downfall is the result of good intentioned policies that have failed the people they're meant to save. Policies that regard the decriminalization of drugs as humane and preconditions to housing, like sobriety, are heartless. Two-thirds of those overdose deaths this year in San Francisco happened inside at a fixed address, and many inside permanent supportive housing. Compassion comes in many forms. Accountability is one of those forms of compassion. I'm not saying that we need to put everyone in jail, but accountability has to be a piece of this. While Denver isn't San Francisco, Wolf says it's headed in that direction. You can build all the tiny homes that you want, but if you continue with this policy of allowing people to use drugs openly, having tent encampments just on sidewalks, you're just inviting more people to come. We're at this crisis level with homelessness and drugs where we can no longer debate about which way is the best way, he said. The answer should just be yes to just about everything, which includes arresting people, which includes holding fentanyl dealers accountable, which includes mandated treatment for those who need it, which includes finding just drug treatment detox, and yes, that includes permanent housing too. Wow. So, very interesting to hear this, and I think there's a lot of truth to this statement. Solutions are in need when it comes to this issue, and it cannot be ignored. Let's move on. Colorado School District targets social media companies in lawsuit. From June 28th, 2023, from John Frank on Axios, Denver. So, of course, our school districts are looking for a scapegoat, and they're looking at social media companies. TikTok and Meta are under fire from a new foe. Aspen School District filed a federal lawsuit this month against the social media companies and others, citing concerns about their impact on youth mental health. The legal challenge, one of more than 40 filed by school districts nationwide, is being compared to the blockbuster lawsuits filed against the tobacco industry in 1999. Our kids are really hurting these days, and social media has really set up their platforms to kind of hook the kids and really just get them addicted to social media, Aspen Superintendent Dave Baugh told Colorado Public Radio. So they're blaming social media companies, of course. I mean, come on, people. It's not the social media companies' fault that children are using these platforms. It's really the children and their parents who should be told not to use these platforms, right? And the schools, of course, are ridiculous jumping on this bandwagon to go after social media companies, in my opinion. In a conversation with the Aspen Ideas Festival this week, advocates for regulation warned of social media's addictive nature and how it affects children, citing studies showing it contributes to depression, loneliness, and drug use. Yeah, 100%. I mean, social media is not necessarily supposed to be used by children. Children should probably not be on the internet very much at all, in my personal opinion. They should be outdoors, enjoying time with their family and friends, exploring the world, and learning about the real world outside of the internet, you know? But of course, this idea of protecting children and using the government to regulate these online media companies in the name of protecting children sure sounds a lot like gun control. Of course, the tobacco control legislation, some of these anti freedom measures that have been pushed with this excuse before, and it should be rejected fully, in my opinion. So, be warned that of course these school districts are trying to blame social media companies and target them, and it is an easy target, right? But the real problems are a lot deeper and bigger than what these media companies are doing to children. Let's move on. This is from the taxfoundation.org. Very unfortunate to see that Colorado is in the crosshairs for increasing taxes. So let's take a look at the specific Colorado bills. So in 2021, the Colorado legislature passed Senate Bill 21-260. So Colorado is phasing in a road usage fee on gasoline and diesel fuel. That means your gas and diesel is getting more expensive because of the state lawmakers, including Jared Polis. On July 1st, the fee on gasoline is set to increase from 2 cents to 3 cents per gallon, and the fee on diesel will increase from 4 cents to 6 cents per gallon. Similarly, the bridge and tunnel impact fee paid by special fuel distributors will increase from 2 to 3 cents per gallon. These so-called fees are levied in addition to the gasoline excise tax of 22 cents per gallon. So when you really think about it, right, these legislators can get away with it by saying it's only 1 cent, it's just a penny. I mean, come on, we got to fix these roads up, it's just a penny. But look at this, they already have 22 cents per gallon of taxes. Then they're increasing another 3 cents and another 6 cents. I mean, it adds up. Enough's enough. Just say no. We need gasoline in our society to work our jobs, to take our kids to school, to live our lives. The government coming in and raising the tax bill on our gasoline is totally anti-Colorado. And it's very unfortunate that these politicians are not being held accountable by being kicked out of office for pushing these types of measures. Unfortunately, there's another tax in Colorado. As part of the road usage fee legislation going into effect July 1st, Colorado will also implement a 27-cent fee on deliveries and a 30-cent fee on ride shares. Now, as you can see, a lot of delivery platforms online have already adopted this, kind of rolling it out ahead of time. But 27-cent fee, it's truly a tax. I mean, these politicians are so dishonest by calling these things fees. That's how they can skirt around the Taxpayer Bill of Rights, which prevents them from doing exactly this. So 27-cent fees on deliveries, that adds up. I mean, people are getting deliveries left and right these days, right? And then 30% fee on ride shares, totally ridiculous. A total outrageous tax coming after Colorado drivers, Colorado delivery drivers, Uber drivers, and the like. So very unfortunate seeing that happen. Taxes need to be resisted at all costs. Taxation is theft, and you deserve to keep the money you earn. Let's move on. The Sum and the Substance, tsscolorado.com. So another law here that started on July 1st, as we just saw these new taxes that lawmakers have burdened Colorado with. The Colorado Privacy Act is something new as well. It subjects companies that collect customer data to significant new regulations. Well, as you may have guessed or know, as you may know, data is a gold mine for moneymakers these days. That is a huge resource, a big commodity, if you will, for tech companies, marketing companies, pretty much anybody who's involved in sales. Data is key. So what do these new regulations do? Let's see. From Ed Sealover from June 30th, 2023. So beginning on July 1st today, Colorado employers who collect and store significant amounts of personal data on customers must allow those individuals to review, correct, and delete that data and must get permission from them if they want to sell any of their information. Employers, interesting. Controllers of the data for these companies must also undertake significant data protection assessments to ensure not only that the information is safe from hackers, but that the information is necessary for company operations. So it's making data collection and data storage a lot more expensive. We can tell that right off the bat from this. Those who fail to comply with the newly enacted Colorado Privacy Act could face penalties that reach as high as $20,000 per violation. Now, of course, these regulations for privacy have to do with attacking the business community, going after businesses, marketing companies, and the like. But it doesn't do anything to stop the government from totally spying on us and stealing our data and even purchasing data from these companies. That's a privacy act I'd like to see. It's restricting the state or local government's ability to collect and use data against the people. The new regulations stem from a law passed with overwhelming bipartisan backing in 2021 and aimed at ensuring that consumers can control the amount of personal data that is available to them. Colorado is just the third state to enact such a law, following similar statutes in California, yuck, and Virginia, but its rules are in some cases more strenuous than those of other states, which has generated national attention to the local efforts. Quote, some companies will be in better position than others, said Lindsay Tonsager, co-chair of the Global Privacy and Cybersecurity Practice at Covington and Burling LLP, noting that national and international firms are likely prepped by existing California and European regulations. But for mid-sized Colorado businesses and even small-sized Colorado businesses that just eke over the threshold limits for data, they have some work to do. So, of course, we see this time and time again with government regulations coming in and benefiting these big corporations, benefiting these companies that have massive amounts of lawyers and can afford to enact or follow these ridiculous policies. So, how does this Privacy Act work? The new rules apply to any company either conducting business in Colorado or targeting products or services to Colorado that controls and processes the data of at least 100,000 consumers annually or sells the personal data of at least 25,000 consumers. That's really not a lot of people when you get into internet marketing. Arguably, the most important feature of the Colorado Privacy Act is its creation of new personal data rights for consumers, the rights of access, correction, deletion, and data portability. Beginning Saturday, consumers can contact any company that has personal data on them, ask to see all the data it's collected, correct inaccuracies, demand data be deleted, and demand it be given to them in a commonly used electronic format if a consumer wants to transfer it to another company. So this is absolutely devastating for anybody involved in sales or marketing. Really restricts people's ability to find consumers, to find people who are wanting to engage with these products and services. Of course, the big corporations, as we discussed, will probably be okay with these laws. The new law also requires that companies receive explicit consumer consent to process sensitive data that it's used to indicate things such as an individual's race or sexual orientation, to sell a consumer's personal data, or to process it for targeted advertising. Controllers of information gathered before July 1st must go back and get consent from consumers to do these things if they have not gotten it already. And those who get consent to use data for one purpose, like providing them targeted offers, must get new consent if they seek to use it in a second way, such as selling information to data brokers. So, very interesting article. You can read it. Of course, I link all of these articles at freestatecolorado.com. Every weekly roundup is fully sourced and has all the links to go do this investigation or research yourself. So, very interesting. On some level, of course, everybody wants more privacy, everybody wants to protect their data. But on another level, the health of the business community relies in producers being able to find customers, right? If you have a product or a service that you're interested in selling, especially if you're a small business, well, using internet data is a great way to do it. So we'll see how this plays out. And unfortunately, it seems like it could cause some serious issues for Colorado businesses and make it harder for small businesses to really reach new customers while allowing big businesses to have a big unfair advantage in the marketplace. Let's move on. So let's move on to the Supreme Court here. Lots of Supreme Court articles. Supreme Court vacates Colorado man's stalking conviction in the True Threat First Amendment issue from June 27th, 2023. The Supreme Court, in a 7-2 decision, tossed a Colorado man's stalking conviction on Tuesday in a case that defines when states can prosecute true threats not protected by the First Amendment. Justice Elena Kagan, writing for the majority, rejected Colorado's test that would weigh how an objective, reasonable person would perceive the statement and would not consider the intent of the sender. Kagan wrote that states must prove the speaker's recklessness for the threat to not be protected, a middle ground between the two parties' proposals. Kagan's decision was joined by conservative Justices Samuel Alito, Brett Kavanaugh, and Chief Justice John Roberts, as well as liberal Justice Ketanji Brown Jackson. Liberal Justice Sonia Sotomayor and conservative Justice Neil Gorsuch agreed with tossing the man's conviction, but they split with the majority in its ruling about true threats more broadly. Conservative Justices Clarence Thomas and Amy Coney Barrett dissented, with each writing a dissenting opinion. Thomas also joined Barrett's dissenting opinion. So the background is that Billy Counterman, whom a jury found guilty of stalking after he sent more than 1,000 online messages to musician Coles Whalen, appealed to the justices, arguing he was diagnosed with a mental illness and did not personally intend for the statements to cause fear. Quote, the statements showed that the defendant consciously disregarded a substantial risk that his communications would be viewed as threatening violence, Kagan wrote. The state need not prove any more demanding form of subjective intent to threaten another. Counterman's messages range from affectionate to hostile, including telling Whalen to die and F off permanently. Wow. So interesting, kind of a nuanced legal argument in terms of what the First Amendment allows and does not, but it could seemingly be a good win for the First Amendment for free speech. Hard to say exactly, but there it is. Before we get to the rest of the Supreme Court articles of the week, I'd like to talk about a local issue that is close to my heart, and that is, of course, eliminating tax on food. Food, you can't survive without it, people, right? I mean, the politicians of the government thinks that they need a piece of that pie, so to speak. They need to take a tax on every item of food that you buy so you can feed your family. I mean, it's totally ridiculous. If something shouldn't be taxed, it's definitely not. It's definitely food. Food should not be taxed at all. So in Loveland, some local activists are standing up. Proposed initiative aimed at Loveland food tax raises some concerns. Of course, that's one way to word the headline. You can kind of see what they're trying to get at. The group collecting signatures to get issue on the ballot. A little picture here you can see some people outside of the library in Loveland on Wednesday about two citizen initiatives they are hoping to add to November's ballot, Stop the Food Tax. In an effort to reduce grocery bills for Loveland shoppers, a citizen group has launched a drive to place an initiative on November's ballot that would eliminate the 3% city sales tax on, quote, food prepared for home consumption. Sounds like a great idea, right? If passed, supporters of the measure estimate that it will save the average Loveland household about $450 per year. That's a lot of money. However, the initiative would also have a negative impact on the city's general fund revenues. Of course, it would. And that has some city staff members concerned about future budget cuts. Well, obviously, these government officials want more money. Um, of course, they want that money for their library administration fees, as this article continues on, and other issues. We've had several people stop and say they're going to lose their jobs if the food tax passes, and I think that's bogus. Someone in the city is telling them this. Massaro, one of the signature gatherers, disputes the notion that the loss of food sales tax will deal a big blow to city coffers and lead to layoffs. We know that money will go right back into the economy, he said. Plus, it allows them to possibly buy more food for themselves. It's not losing money, it's going to come back into our economy, and it's probably coming back locally. So, I mean, this is a great idea, right? Okay, here we go. The city would lose approximately $9.5 million per year if there were no sales tax on food, or about 16% of the 2023's budgeted sales tax revenues of $60 million. As we've seen, homelessness is increasing. A lot of people are struggling to get by. We're seeing the state government increase taxes on our gas, on our ability to get food delivered to our homes. So this is extremely reasonable for people to want to, save money on their food bill. The food bills have gone up a lot, right? So $450 a year for an average family, that's a lot of money. So props to these people who are pushing this initiative. It's great to see citizen activists get involved, stand up for their community, and push back against this out of control government that just seems to get larger and larger, taking more of our money, more of our hard earned money away from us and our households. Let's move on. Talk about taking money away from our households. Proposition HH is terrible and should be should be opposed at all costs. So this is from Paul Joshua Bustamante from June 29th, 2023. Proposition HH is deceptive, devious, and unconstitutional. Well, here. Politicians are like Scooby-Doo villains, outwardly friendly but secretly cold and devious. But instead of robbing people with harebrained schemes, politicians manipulate ballot questions to swindle voters out of their hard earned money. And that's exactly what they're doing with Proposition HH. The architects of the measure advertise it as a property tax relief. It is, sort of, but its primary function is to end taxpayer refunds. Putting these two unrelated topics into the same bill may seem strange, but it was a calculated political move. Politicians inserted property tax reform into Proposition HH as a bait and switch to win consent for ending taxpayer refunds. And they would have gotten away with it too if it weren't for a meddling lawsuit. Last month, a group of citizens in Colorado counties sued the state, arguing Proposition HH and the bill that put it on the ballot, Senate Bill 23303, violate the state constitution. This summer, they will make their case before the Colorado Supreme Court. The suit highlights two primary constitutional infringements. First, the Colorado Constitution has a provision that requires bills to address only one subject, the single subject rule. This prevents a party from log rolling or lumping an unpopular policy in with a more popular one to help get the former adopted. Proposition HH violates this rule in textbook fashion. After increasing property taxes by around 40%, politicians have offered a slightly smaller tax increase with Proposition HH, but Coloradans will only get that relief if they vote to give up taxpayer refunds forever. Wow. So let's hope it gets stopped. Proposition HH, of course, needs to be opposed, and let's hope that the Colorado voters can see through the lies of our governor and the state legislature to strip us of our taxpayer refunds. Let's move on. interesting article here about what's going on in Edgewater and Jefferson County. From the denverpest.com, Jeffco DA requests a state investigation of Edgewater Police Department, citing, quote, bullying, retaliation, and bending of the rules. Colorado's Attorney General's office asked to conduct a pattern and practice investigation after new charges were filed against ex-cop. So Edgewater in hot water. This is updated on June 30th, 2023. Sam Tabashink. Jefferson County Attorney Alexis King on Thursday announced that her office has asked the Colorado Attorney General to open an investigation into the conduct of the Edgewater Police Department, an agency her office described as being fraught with bullying, retaliation, and bending of the rules. The request for a pattern and practice investigation comes on the heels of new charges levied this week against a former Edgewater police officer, Nathan Gerdes, accused of sexually assaulting a fellow officer, falsifying documents, and retaliating against a witness. A subsequent investigation found between 2016 and 2021, certain members of the 20-officer police department may have violated the constitutional rights and privileges of individuals in Colorado, the DA's office said in a news release. In 5 instances, officers had questionable authority to engage with the suspect and make arrests. King wrote in a June 26 letter to Colorado Attorney General Phil Weiser. Some of those incidents also involved police entering homes and using force, including tasers, she wrote. Others included concerns over altered documents, evidence tampering, and destruction of evidence during a questionable death investigation. Wow. So very interesting to see this happening in Edgewater, to see a Jefferson County District Attorney trying to hold them accountable for possibly a violation of the law, it seems. What's interesting too, Edgewater has been one of these small towns in Colorado that has tried to pass anti-gun legislation. So here we go, right? These anti-gun people think that only the police should have guns. The city government should be deciding who and who cannot own firearms. That's what Edgewater government's trying to do. And their own police department is using force, falsifying documents, entering people's homes. I mean, come on, people. You think these are the only people that should be allowed to have firearms in our society? Can you see what kind of system this sets up? It's not good. It's not good. So, very interesting to see this happen in general, but especially in Edgewater. And I think this is a good argument against this gun control legislation, gun control bills, ordinances, what have you, that Edgewater has been trying to force on their citizens. Check that article out if you're interested. But let's go ahead and dive into the Supreme Court. From the Epic Times. So, very Colorado centric article here. Supreme Court rules for Christian web designer enforced speech case. Matthew Vadum, June 30th, 2023. The Supreme Court ruled 6-3 in favor of a Christian website designer who said Colorado's law requiring her to create websites to celebrate same-sex weddings infringed on her constitutional rights. So it's very unfortunate, but Colorado's state government has a long history of persecuting Christian business owners and attacking people who who have a difference of opinion, who believe in their own thoughts outside of what the government tells them they should do. Justice Neil Gorsuch wrote the majority opinion. You can read the PDF there. In 303 Creative LLC versus Alanis, Court File 21-476, which was decided June 30th. The opinion was joined by Chief Justice John Roberts, along with Justices Clarence Thomas, Samuel Alito, Brett Kavanaugh, and Amy Coney Barrett. The 3 liberal justices dissented. President Joe Biden called the new decision disappointing. Left-wing activists have been targeting bakeries for years for political purposes, asking Christian confectioners opposed to same-sex marriage to bake wedding cakes for gay marriage celebrations. When the bakers refuse to make the cakes, these activists sue under anti-discrimination laws, hoping to secure favorable legal precedents. So, of course, in Colorado, there's Masterpiece Cake Shop versus the Colorado Civil Rights Commission in 2018. The Supreme Court sided with Jack Phillips, a Christian baker whom a gay couple had asked to create a custom cake to celebrate their union, finding a state human rights commission had violated his First Amendment right to free exercise of religion. So, as we've seen, Colorado, unfortunately, has a history of targeting business owners and individuals who have Christian beliefs and who dissent from the state's ideas. But in this case, the case at hand, artist and website designer Lori Smith of 303 Creative complained she was being singled out by the same Colorado Human Rights Commission because, based on her religious faith, she does not support non-traditional marriage. Smith has said she will design custom websites for anyone, including those who identify as LGBT, so long as their message does not conflict with her religious views. This is called compelled speech, forced speech, where they force an individual to act against their beliefs. It is absolutely wrong, and shame on the Colorado government for pushing this agenda on our community, and good on the Supreme Court for slapping Colorado government in the face. This means that she will not promote messages that condone violence or encourage sexual immorality, abortion, or same sex marriage. When clients want such messages expressed, Smith refers them to other website designers. Smith took action when she discovered she was forbidden under the Colorado Anti-Discrimination Act, totally unconstitutional act it seems now, CADA, to post a statement online explaining what content she was and was not willing to create. Smith's attorney, Christian Wagner of Alliance Defending Freedom, told the justices during oral arguments on December 5th, 2022, that Smith, quote, blends art with technology to create custom messages using words and graphics. She serves all people, deciding what to create based on a message, not who requests it. But Colorado declares her speech a public accommodation and insists that she can create and speak messages that violate her conscience. Colorado government, let me read that again, insisting that she speak messages that violate her conscience through threat of law. The Colorado government wants to throw people like Smith here in jail at the point of a gun for refusing to speak messages that violate her conscience. I mean, that is extremely anti-American. If any government may not force motorists to display a motto, school children to say a pledge, or parades to include banners, Colorado may not force Ms. Smith to create and speak messages on pain of investigation, fine, and re-education. Wow. In the 26 majority opinion, Gorsuch wrote, quote, like many states, Colorado has a law forbidding businesses from engaging in discrimination when they sell goods and services to the public. Laws along these lines have done much to secure the civil rights of all Americans. But in this particular case, Colorado does not seek to ensure the sale of goods or services on equal terms. It seeks to use its law to compel an individual to create speech she does not believe. The question we face is whether that course violates the free speech clause of the First Amendment. In this case, Colorado seeks to force an individual to speak in ways that align with its views, but defy her conscience about a matter of major significance, Gorsuch wrote. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Yes. Nor in any event do the First Amendment's protections belong only to speakers whose motives the government finds worthy. Its protections belong to all, including the speakers whose motives others may find misinformed or offensive. So great news, great message here on the eve of our Independence Day, 4th of July just being around the corner, that the Supreme Court is at least standing up. At least there's somebody out there standing up for the rights of Coloradans as the state government continues to target individuals. Let's continue on with this line of thought here. From the Federalist.com, 8 straight fire quotes from Neil Gorsuch's defense of free speech in 303 Creative from June 30th, 2023, Sean Fleetwood. Writing for the majority, Neil Gorsuch left little doubt the current Supreme Court has a vested interest in defending Americans' First Amendment rights. Justice Neil Gorsuch offered a straight-fire defense of free speech and religious liberty in the U.S. Supreme Court's 303 Creative versus Elena's decision on Friday, which represented a major win for Americans' First Amendment rights. Let's get to some of these quotes. Gorsuch blasted Justice Sonia Sotomayor in the dissent for distorting the facts of the case. Quote, it is difficult to read the dissent and conclude we are looking at the same case. Much of it focuses on the evolution of public accommodation laws and the strides gay Americans have made towards securing equal justice under law. And no doubt there's much to applaud here. But none of this answers the question we face today. Can a state force someone who provides her own expressive services to abandon her conscience and speak its preferred message instead? When the dissent finally gets around to that question, more than halfway into its opinion, it reimagines the facts of this case from top to bottom. 2. State-enforced speech is a blatant violation of the First Amendment. If Mrs. Smith wishes to speak, she must either speak as the state demands or face sanctions for expressing her own beliefs, sanctions that may include compulsory participation in, quote, remedial training filing periodic compliance reports as officials deem necessary, and paying monetary fines. Under our precedents, that is enough, more than enough, to represent an impermissible abridgment of the First Amendment's right to speak freely. The dissent's arguments in favor of coercing Smith's speech are illogical. In some places, the dissent gets so turned around about the facts that it opens fire on its own position. For instance, while stressing that a Colorado company cannot refuse the full and equal enjoyment of its services based on a customer's protected status, the dissent assures us that a company selling creative services to the public does have a right to decide what messages to include or not include. But if that is true, then what are we even debating? The First Amendment guarantees free speech protections for all Americans. The First Amendment extends to all persons engaged in expressive conduct, including those who seek profit, such as speechwriters, artists, and website designers. If anything is truly dispiriting here, it is the dissent's failure to take seriously this court's enduring commitment to protecting the speech rights of all comers, no matter how controversial or even repugnant many may find the message at hand. Well, you can read the rest of those quotes at that article, always linked on the website, of course, at freestatecolorado.com. But let's move on. Here we go. Let's see now the flip side here from the Colorado Sun, a very left-leaning organization here. Colorado Sun and the Associated Press kind of working together here. In LGBTQ rights defeat, U.S. Supreme Court rules Colorado can't force designer to make website for gay couples. So, of course, the Colorado Sun has to lead with what's important on their perspective to their writers, to their supporters, to their readers, I guess, is that the court ruled 6-3 for designer Lori Smith, despite a Colorado law that bars discrimination based on sexual orientation, race, gender, and other characteristics. So, of course, Colorado Sun wants you to think that Lori Smith is discriminating against somebody based on their sexual orientation, and that this is a broader defeat against the LGBTQ rights movement, apparently. There's Lori Smith there in her office doing some website design. Jessica Gresco, Associated Press, and Elliot Wenzler, Colorado Sun. So, of course, the Colorado Sun frames the article, frames their little propaganda piece here by saying, in a defeat for gay rights, the Supreme Court's conservative majority ruled on Friday that a Christian graphic artist who wants to design wedding websites can refuse to work with same-sex couples. Wow, that's not exactly, as we read earlier, not exactly what's going on, of course. One of the court's liberal justices, so they go to the liberal justice first, because that's what's important to the Colorado Sun and the Associated Press, of course, wrote in a dissent that the decision's effect is to, quote, mark gays and lesbians for second-class status. And that opens the door for other discrimination. So, of course, the Associated Press, Colorado Sun, wants you to think that the Supreme Court is making it easier for gays and lesbians to be treated as second-class citizens and be discriminated against. That is the point of their article. That's the number one thing they want people to take away from this. And it's totally dishonest. And it's totally shameful that this is, Colorado Sun just reveals itself as a total propaganda organization here. So we can kind of skip that paragraph there. And then they go on to Smith's opponents, of course, warned that a win for her would allow a range of businesses to discriminate, refusing to serve Black, Jewish, or Muslim customers, interracial or interfaith couples, or immigrants. But Smith and her supporters had said that a ruling against her would force artists, from painters and photographers to writers and musicians, to do work that is against their beliefs. Wow. Wow, wow, wow. And then, of course, here we go. When they start talking about the Supreme Court, this article immediately brings in Donald Trump, right? They're trying to totally frame this argument as a Trump conservative, anti gay discrimination type of case, which is not the case, as we already saw. Justice Neil Gorsuch, a Coloradan, nominated to the court in 2017 by then President Donald Trump. Oh my gosh, the evil man himself, wrote for the court's 6 conservative justices. He said that Colorado was forcing Smith, quote, to speak in ways that align with its views but defy her conscience. Abiding the Constitution's commitment to the freedom of speech means all of us will encounter ideas we consider unattractive, misguided, or even harmful. But tolerance, not coercion, is our nation's answer, Gorsuch wrote. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Because Colorado seeks to deny that promise, the judgment is reversed. And then, of course, they go into the dissent, continue with the dissent. And then, of course, the article goes on to expand the bigger issue about gay rights, because that's what they care about more so than the rights of individuals to make their own decisions and to live their lives based on their own conscience. Of course, let's hear what Colorado Attorney General Phil Weiser, a Democrat whose office is the one that's persecuting the defendant here, the 303 Creative. So he blasted the opinion, according to the Colorado Sun here, saying, quote, "This deeply concerning opinion is far out of step with the will of the American people and American values." So, of course, he doesn't reference the constitutionality of it. He says it's more about the will of the American people and American values. The opinion represents a radical departure from decades of court precedent and fails to uphold the principle of equal justice for all inscribed on the U.S. Supreme Court building. Of course, Phil Weiser thinks you should be forced at gunpoint to attend re-education classes if you disagree with his mandated speech. If you decide not to speak against your values, then you should be threatened with violence, fines, and worse, of course. Unbelievable. Weiser said in a news conference in downtown Denver that, quote, "The ruling promises to destabilize the public marketplace." Oh my gosh, enabling and encouraging all types of businesses, not just those who make websites, to have a First Amendment right to refuse customers because of who they are. Wow. Absolutely insane that Phil Weiser, they, of course, going to pull us and the rest of it and continue on. The Colorado Sun is a shameful organization pushing an agenda that is out of step with the U.S. Constitution, out of step with the rights of Colorado individual business owners, and it's very unfortunate. So, congratulations to Lori Smith for winning her case. Let's continue on here and see that wasn't the only Supreme Court case, of course, in the news, but let's just look at a couple other politicians and activists reacting. This is from the denvergazette.com, slightly more right-leaning than obviously much more right-leaning than Colorado Sun, but still relatively milk toast in many ways. So we already talked a little bit about Phil Weiser. I think we've heard enough of what he had to say. Let's hear Christian Wagner, the CEO and president, the general counsel of the Alliance Defending Freedom. The U.S. Supreme Court rightly reaffirmed that the government can't force Americans to say things they don't believe. The court reiterated that it's unconstitutional for the state to eliminate from the public square ideas it dislikes, including the belief that marriage is the union of husband and man. Disagreement isn't discrimination, and the government can't mislabel speech as discrimination to censor it. Lori works with everyone, including clients who identify as LGBT. As the court highlighted, her decisions to create speech always turn on what message is requested, never on who requests it. The ruling makes clear that non-discrimination laws remain firmly in place, and that the government has never needed to compel speech to ensure access to goods and services. This is a win for all Americans. The government should no more censor Lori for speaking consistent with her beliefs about marriage than it should punish an LGBT graphic designer for declining to criticize same-sex marriage. If we desire freedom for ourselves, we must defend it for others. Governor Jared Polis. Let's see what he has to say. You can pretty much guess what he's going to say about this. Sadly, the U.S. Supreme Court decided in favor of discrimination and against student loan relief today. These misguided rulings come one day after the Supreme Court overturned decades of precedent and potentially stifled future educational opportunities. We are committed to building a Colorado for all, where the pure, powerful few do not control the freedom of all the Coloradans, blah, blah, blah. Michael Bennet, of course, is against it. He wants the Senate to pass the Equality Act, which would, I'm sure, mandate and force people across the country to do what the government wants them to do against their own will and conscience. Of course, John Hickenlooper jumps on the train talking about hate speech and talking about Sotomayor, a new license to discriminate. And of course, retweeting the Colorado Sun article, retweeting the Colorado Sun article that clearly frames the argument as an LGBT issue. And Diana DeGette goes even stronger, saying this is disgusting. GOP-backed extremists. I mean, she is one of the most far left congresspeople we have, who is not criticized as much as she should be. Doug Lamborn, I'm sure, is on the right side here, retweeting Alliance Defending Freedom. Today's Supreme Court ruling in favor of Colorado's 303 Creative and Lori Smith is a victory for free speech and religious liberties everywhere. Americans of all faiths deserve First Amendment protections as they seek to uphold our fundamental beliefs. Hashtag free speech for all. Bobert, today is a huge victory for religious liberty. Glad to see the Supreme Court make the right call here. Brianna Titone, you can imagine what she's going to say. We can skip that. Tammy Story, of course, is not happy with it either. Blah, blah, blah. They continue on. So, really, what you can see is what you expect, but interesting to see how out of touch and out of step, and how these politicians really frame their arguments based on a political position rather than a constitutional position. A few more articles. Here we go. The Daily Camera. So, the other Supreme Court, as we kind of alluded to in the last one, CU officials, state leaders react to Supreme Court striking down affirmative action. Olivia Doak, June 29th, 2023. Elected state officials and leaders at the University of Colorado reaffirmed their commitment to diversity in higher education after the Supreme Court ruled against race conscious admission policies. So, this obviously was a great decision by the Supreme Court for anybody who believes in merit based society and based on non discrimination. Interesting to see that the Supreme Court standing up against discrimination when of course, those on the left, the Democratic left, are in favor of discrimination, unfortunately. The U.S. Supreme Court ruled on Thursday that colleges and universities are no longer allowed to consider race as a factor in the college admissions process, known as affirmative action policies. Now, of course, if these colleges and universities were considering the wrong type of race, I'm sure the Democrats have a problem with it. But of course, they want to favor specific classes of people for benefit that they see as politically advantageous. CU Boulder Chancellor Phil DeStefano released a statement detailing the steps the university will take to continue creating a diverse and equitable environment on campus. Quote, based on a well established body of research, we know that an organizational commitment to diversity, equity, and inclusion, DEI, that's bad news, can improve critical thought, problem solving, and classroom engagement, reduce bias, and promote professional development, civic engagement, and leadership, DeStefano said in a statement. I want you to know that I am committed to equity and in supporting students that this ruling directly impacts. Wow. So the Supreme Court's conservative majority overturned affirmative action admissions policies in cases brought forward involving Harvard, and the University of Northern Carolina. So it is a good win, but of course, as the usual suspects, as you may expect, were against this. U.S. Representative Ken Buck, however, wrote in a tweet that he supports the decision of the court, quote, as a first step to bringing our collegiate institutions back to merit-based admission. Equal protection under the law is one of the bedrock principles of our constitutional republic, wrote Buck, a Windsor Republican who represents Colorado's 4th Congressional District. For too long, young people were deprived of that protection depending on the color of their skin, thanks to race based college admission processes. Today, the Supreme Court restored that protection and declared racial determinism in the admissions process unconstitutional. Wow. Of course, Phil Weiser, nominee for the Clown of the Month here, said that this court's misguided conclusion, claiming that these longstanding policies violate the Constitution, threatens to undermine the progress we have made on college campuses to create access for all Americans and ensure diverse learning environment for all. So, of course, in their eyes, in Phil Weiser's eyes, discrimination is necessary because how else will you have a diverse learning environment? Pretty telling what their beliefs are. Couple last articles here. Let's just take a look here at how the Denver Gazette reports on this Supreme Court ruling against affirmative action. Colorado University signal modifying DEI approach after Supreme Court strikes down affirmative action. So Colorado University signaled they would modify their approach to diversity goals following the U.S. Supreme Court's decision to strike down the race-based components of the admissions programs at Harvard and University of North Carolina. Education officials said their commitment to diversity, inclusion, equity, and access will not diminish. But the overarching question facing universities is how, right? That's very, very true. You should not be determining who's going to be attending your taxpayer funded university based on the race that they have, of course. So this article kind of reiterates some of what the last article said, but it's interesting to see how the argument's slightly framed differently in the Denver Gazette article. So very, very interesting. Let's move on to the last little bit here. How the Colorado Sun frames the article. I wanted to create that contrast between Daily Camera, actually relatively reasonable, Denver Gazette, a little bit also relatively reasonable, kind of approaching both sides of the article. And then here's the Colorado Sun again, just so you can see this bias. Colorado universities will double down on diversity after Supreme Court effectively barred affirmative action. Here's how Colorado colleges are responding. So interesting to see how they're framing the argument. Last article of the week here. The other Supreme Court ruling, Colorado leaders react to Supreme Court rejection of Biden's student debt forgiveness plan from denvergazette.com. There's crazy people here demonstrating outside the Supreme Court saying student debt is a gender racial equity issue. Okay. And it is subscriber only premium content. So unfortunately, we will be skipping that this week. But anyways, thank you very much, everybody, for being here on freestatecolorado.com. I think it's been on long enough now at 55 minutes, probably the longest one ever, but so much to cover, so many interesting things, and best wishes. Hope to see you next